A federal appeals panel ruled a California gun law unconstitutional. The law is still being enforced anyway, months later, on every single ammunition purchase in the state. That is not a contradiction, and it is not a conspiracy. It is exactly how one specific, genuinely confusing piece of federal appellate procedure works, and it is happening right now in a case called Rhode versus Bonta. If you have seen vague claims online about ammunition access disappearing, this is the real, specific, currently unresolved legal fight most likely underneath at least some of that noise. Let's walk through exactly how this case got here and exactly what its current unusual status actually means. Quick housekeeping. I trace specific court cases through their actual procedural history, not just the headline the day a ruling comes down, because a case like this one shows exactly why that distinction matters. If that is useful, subscribe and turn on the bell. 2 seconds and let's get into how this case actually got to where it is. Start with the law itself. In November of 2016, California voters approved Proposition 63, a ballot measure that, among other provisions, required background checks for ammunition purchases starting in 2019. Under this system, buying ammunition in California means presenting identification and clearing a background check at the point of sale, every single time, for every single purchase, whether you are buying a single box at a local shop or having ammunition shipped from out of state to a licensed vendor for pickup. California and New York remain the only two states requiring this specific kind of point-of-sale background check on every ammunition transaction, a narrower and more demanding standard than the broader ammunition background check systems in a handful of other states. Kim Rhode, an Olympic shooter with multiple medals across 6 consecutive Olympic Games, joined the California Rifle and Pistol Association in challenging this law, arguing the background check requirement violates the Second Amendment by imposing a substantial burden on the ability to acquire ammunition necessary to actually exercise the right to keep and bear arms. The case, filed back in 2018, worked its way through the federal court system for years before reaching a 3-judge panel of the Ninth Circuit Court of Appeals. In July of 2025, that 3-judge panel ruled in Rhode's favor, finding California's ammunition background check requirement unconstitutional. This looked at the time like a genuinely significant result. The Ninth Circuit is not generally known as a court sympathetic to Second Amendment challenges, and a ruling against California's law from that specific court carried real weight as a signal. Here is where the case takes the procedural turn that actually defines its current status. California's Attorney General, Bonta, petitioned for what is called en banc review, asking the full Ninth Circuit, rather than just the original 3-judge panel, to rehear the case. On December 1st, Chief Judge Mary Murguia signed an order granting that petition, which automatically vacates the original panel's ruling the moment en banc review is granted. This is a critical detail that a lot of casual coverage of this case gets wrong. Once the full court agrees to rehear a case, the original panel's decision no longer has any legal effect at all. It is as though that ruling never happened, at least until the en banc panel issues its own new decision. That is exactly why California's background check requirement has continued being enforced without interruption, despite a federal appeals panel having already ruled against it. The ruling that would have struck it down simply does not currently exist as valid law. The en banc panel, made up of 11 judges rather than the original 3, heard oral arguments on March 25, 2026, in Pasadena. As of this recording, that panel has not yet issued a decision, and there is no fixed timeline for exactly when one will arrive. En banc rulings frequently take months to be released after oral argument, particularly in a case this legally significant with this many judges needing to reach and write out a shared position. Let's talk about what happens next, because there are genuinely different paths this case could take from here, and each one matters differently for California gun owners specifically, and for ammunition regulation nationally. If the en banc panel upholds California's background check requirement, the law simply continues exactly as it currently operates, and Rhode's team would need to petition the Supreme Court directly if they wanted to continue the fight, with no guarantee the court would agree to hear it. If the en banc panel strikes the law down, mirroring the original 3-judge panel's conclusion, California would then face its own choice, whether to seek Supreme Court review itself or simply accept the loss. This second scenario is worth understanding in more depth, because legal observers following the case have flagged a genuinely interesting strategic wrinkle. Some analysts believe California might actually prefer to accept a loss at the circuit level, letting the requirement fall only within the Ninth Circuit's own states, rather than risk asking the Supreme Court to weigh in and potentially issue a nationwide ruling against ammunition background checks generally, which would reach considerably further than just California and could affect New York's similar law as well as any future state considering a similar requirement. In other words, the specific plaintiffs and the specific defendant in this case may have somewhat different incentives about whether to push this all the way to the Supreme Court, independent of who technically wins at the en banc stage. Here is what this means practically if you are a California gun owner right now, today. The background check requirement is not going anywhere in the immediate future, regardless of what you may have heard. You will continue showing ID and clearing a check for every ammunition purchase until the en banc panel actually issues its ruling, and even then, further appeals remain possible depending on which side loses. If you are trying to time a major ammunition purchase around this litigation resolving, understand that there is no reliable timeline here. En banc decisions in cases this significant can take anywhere from several months to over a year after oral argument, and planning around a specific date is genuinely not possible with the information currently available. Step back and look at what this case actually illustrates beyond its own specific facts. A single ruling from a three-judge panel, even a Ninth Circuit panel ruling against a California gun law, is not necessarily the final word, and treating any single circuit panel decision as settled permanent law is a mistake that shows up constantly in how legal news gets summarized and shared. This case is a clean, current example of exactly that gap, a real ruling, genuinely in favor of the challengers, that currently has zero legal effect because a higher level of the same court agreed to take a second look. Understanding that distinction between a ruling that exists and a ruling that is currently controlling law is worth carrying into how you read coverage of any pending case, not just this one. If tracing this specific case's actual procedural path was useful, hit like so it reaches other people trying to understand why California's ammunition background checks are still running despite a ruling against them, and subscribe if you have not, because I will cover the en banc ruling itself the moment it comes down, whichever direction it goes. Tell me in the comments whether you want the next video to cover the substantive Second Amendment arguments on both sides of this case in more depth, or to wait until the en banc ruling actually lands and cover it fresh at that point.